right. Pat, Dave, if everybody's okay, I'm going to get started. So as Dave indicated, my name is Ryan Nerney. I'm a partner in the Southern California office. My primary practice areas are federal employment, which includes representation at various different forums, including MSPB and EEOC, as well as several different disciplinary actions that agencies can take against employees. I also deal with national security issues as well here at the firm.
And my name is Andrea Ennis. I'm an associate in the firm's Albany office. I graduated from Toro Law School, and I have currently started to dedicate myself to learning and practicing primarily in reasonable accommodation requests and those areas related to the COVID vaccine mandate.
All right, and today in this webinar, what we're going to go over is the executive orders 14042 and 14043, both for federal employees and federal contractors. Going to go over the types of accommodations that you can, or exceptions that you can receive, which is medical and religious. The road ahead as far as potential disciplinary actions that agencies can potentially take against employees who refuse or do not comply with the executive order. And then at the end, as Pat indicated earlier, we'll go over a few common questions that we've been hearing and see if we can get to some of your questions that you guys put in the chats. And I'm going to turn it over to Andrea so she can, go over the first aspect of this.
Thank you very much. So Executive Order 14043 deals with those employees in federal service in the competitive service hired under Title V. Basically, what the executive order entails is that all employees, absent an accommodation that has been approved by their agency, need to be fully vaccinated for the COVID-19 virus. Basically, what that means for anyone that has not already received the vaccines is that unfortunately you will not meet the deadline of November 22nd. As noted on the slide, in order to have been compliant, the dates to receive the second dose for Pfizer and Moderna were November 8th, and Johnson & Johnson, which is the one shot, was November 8th. However, you may still be able to apply for an accommodation, which we will discuss in later slides. Now, this mandate applies to all employees. This is not an agency-issued mandate. This is above the agencies directed by the president. So any employee that is currently employed must also comply with it, as well as those who come into federal service as a new hire. Exceptions do exist for mission-critical hiring, in which the timeline to become vaccinated could be 60 days within the start date instead of at the start date. And then Executive Order 14042, that applies to federal contractors. On-site contractors will need to attest to their vaccination status. The contractor, the prime, or any tier underneath the prime, is responsible for ensuring that the employee attests truthfully to their vaccination status. Further, excuse me one second. There we go. On-site contractors who are not fully vaccinated or who decline to provide information about their status must provide proof of a negative COVID-19 test from no later than previous 3 days prior to entry to a federal building. Now, the difference here is that with the Executive Order 14042, this is not going to apply moving forward unless the facility maintains those COVID-19 safeguards in that facility. Also, agencies are allowed to determine the nature of the contractor's responsibility to allow for no other safety protocol other than being fully vaccinated. So an example of that would be if someone is primarily working in a SCIF or other secure area where there is no free-flowing air exchange, the agency would be able to contract with the prime that anyone working in those worksite locations would be required to be vaccinated. Reasonable accommodations are the only exception to the executive orders. It is important to note that these are accommodations. These are not exemptions in the typical sense of the word. And what that means is that not only are you required to request an accommodation, you are not completely exempt from taking the vaccine, meaning you have to do something in lieu of receive the vaccine. So what that entails is you communicating to the agency that you're not able to be vaccinated either due to a medical condition, such as an allergy, if your doctor agrees and signs off on a form saying, some other condition. I just know the allergy one is very common due to the CDC regulations or recommendations. Agencies are allowed to request further information regarding an accommodation request. So what that means is for a medical accommodation, they are allowed to ask for further documentation regarding the condition itself. This is not a blank check for the agency to dig through an employee's medical records, especially considering that, there may be a concern of using that against the employee later. The employee has reasonable expectations of privacy regarding that, but if the condition is called into question by the employee, then the agency is allowed to request further information regarding that condition. Related to that, the religious accommodation, what they're looking for is they are not looking for whether or not the person believes the belief they're presenting to the agency. They're looking for the sincerity of that belief. And the difference is that the sincerity of the belief is a judge of whether that belief guides that person's everyday life. And that's the line from the EEOC as well. So regarding further information about that, they would be able to request certain things like further information about what the belief was, when you, not like an exact date, but, when did you start believing? Oh, well, I started believing, when I was a child and I was raised this way, just as an example for an answer. They are allowed to ask for that information. And this is what I was mentioning before. Many of the agencies required these accommodation requests to be placed before or on November 8th. Other agencies have moved that deadline to November 22nd to provide the employees with more time to complete their request. It's important to note, though, that accommodation requests have been around for decades. This is not a new system that has been put in place for the COVID-19 vaccine mandate. What that means is that there are plenty of laws and regulations around this, and accommodation requests can be made at any point when the employee submits the request or communicates to the agency that they are in need of an accommodation. The onus is on the agency to engage in the interactive process at that point with the employee to determine exactly what accommodation requests or accommodations they can provide in response to that request, so that the employee will be able to continue working. So the next part of that, of course, if an exception or accommodation request is granted as a result of the reasonable accommodation request, the employee still needs to comply with whatever the accommodation requires in lieu of receiving the vaccine. That could be masking, physical distancing, testing protocols, as well as, specific travel guidance. There are certain ways where the agency is allowed to deny an accommodation, in which case, if it's an essential function of their position, that may be an issue in providing an accommodation to that employee. Beyond that, it's going to be a matter of what the agency and the employee come to an understanding or an agreement about. If an employee has already received their first dose of the vaccine, the employee should receive their second dose within 2 weeks of the final determination to deny an accommodation. If for some reason an agency has not provided a response to an employee and they have put a request in, but they begin disciplinary action, that is a problem. There are certain instances in which the employee should not have disciplinary action taken against them until the agency has provided them with a response. So the next part of what we want to discuss is the medical accommodation forms and what you guys are looking at when you're applying for these medical accommodations and religious accommodations. So the religious exception template to the COVID-19 vaccination requirement was put out by the Safer Federal Workforce Task Force in response to the executive order and the instructions by President Biden when he issued the order. The initial questions that came out were a set of 7 questions. Those questions involved specifics about the person's beliefs, about any prior vaccines they had received, and certain information regarding any other objections they've had to medications or procedures related to their beliefs. The questions were a little upfront and blunt. The reason being is agencies are supposed to walk into the interactive process and discussion with the employee with the presumption that the sincerely held belief the employee is presenting is valid. These questions seemed to preempt that assumption. The reason being is that, unfortunately, with the political nature of the situation right now, there are people that are not sincere. So the reason the agency and the task force are using these questions is to avoid any unnecessary conversations regarding sincerity. If an employee is not able to provide responses to these questions, then it is very unlikely that the employee was sincere enough in their belief to qualify under the EEO standard of a sincere belief to qualify for an accommodation.
Yeah, Andrew, and just to add to that too, these questions, a lot of the agencies are utilizing these types of questions, these specific questions, but some agencies have a different version of these questions, but ultimately they're still trying to get to the same information. So
yeah, exactly.
So they may not be verbatim, but they're essentially trying to get the same information that these questions are trying to see.
Ryan brings up a great point. One of the most common ones that we've seen is the DD 3177 form. That form has gone through many iterations, and the current form has actually narrowed the scope of these questions to only deal with the COVID-19 vaccine, not all vaccines that the employee has ever received. So the next thing to discuss would be the medical exception template. The thing to remember with a medical exception request is that the doctor is required to provide a statement that the employee should not receive the vaccine. Generally, what we see is that the statement consists of that the risk outweigh the benefits, and that therefore, as a result of the employee's condition, they should not receive the COVID-19 vaccine, and they should be provided an accommodation related to that. There's not really a lot for the employee to do with this form. Part one basically just consists of what your name is, the department position, typical things you would fill out on an employment form, and what you are requesting as an accommodation, which is that medical or disability exception request. You can name the condition if you want, but the attestation from the doctor should include your condition that is causing the risk of you receiving the vaccine. When both of these forms are completed, you have to submit them to your agency's designated point of contact. I know that a lot of the agencies have set up a streamlined process for these requests due to the sheer volume of them. So long as the agencies are following, the reasonable accommodation process, as we've briefly discussed here, obviously is much more complicated and fact specific to each person. But in general, as long as the agency is engaging in an interactive discussion with the employee, as long as the agency is considering the request in the legal and lawful manner, there should be no issue regarding, at least in this aspect, the employee's condition. It should just be a matter of whether or not the agency can provide the accommodation. And part two is what I was discussing before. This is the part that needs to be completed by your medical provider. What we are running across is employees have letters from doctors, which is difficult in and of itself at the moment to receive. But because the doctor has not completed this specific section of the form, they're being required by their agency to go back and fill out this form again, which is causing a delay in getting this completed for them. So it's just important to remember that if you have the letter from your doctor or, doctor's note on a prescription pad, however it may come, contact your doctor as soon as possible and get this form completed so you don't run into unnecessary delays later on. So, of course, the next part is, what should you communicate with your agency while they're reviewing your accommodation request? You should basically, again, be engaging in that interactive discussion with them. You need to make sure that you're following up on your requests. It's very important to remember that there is no distinct time frame in which an agency is required to process these requests. The EEOC case law and guidance is just a reasonable time. Well, given the sheer volume of the amount of requests they're receiving and things that go into that and discussions with employees, requests for further documentation, I'm sure you can guess and imagine that that time frame is going to be extended from what we would normally see in a reasonable accommodation request process. So the current guidance on medical or disability requests and what constitutes a reasonable request, obviously an allergic reaction from a prior dose of the COVID vaccine. If a person received the first dose and they had an adverse event that is tied into receiving that first dose, they would qualify 9 times out of 10. It would be up to what the accommodation at that point would be for, an exemption from the vaccine mandate. There's also current CDC guidance on pre-existing health complications. A lot of that guidance focuses mainly on temporary accommodations. It's important to remember that if a condition is permanent and your doctor asserts that it is too much of a risk for you to have that accommodation, it doesn't need to be a temporary accommodation. The agency does have the ability in certain circumstances to reassess and reevaluate an accommodation if it is now a burden on the agency, an undue burden on the agency to provide that accommodation. So, and again, the agency timeline to review these requests, what that kind of boils down to is, for your purposes, is, are you going to face disciplinary action if the agency takes too long to process these? The answer to that should be no. The agencies have been directed not to take disciplinary action on any employee that currently has a pending accommodation request. This has been further asserted in cases like Church v. Biden administration. In that case, they applied for a temporary restraining order on the mandate being enforced as a result of the fear of employees receiving some type of disciplinary action as a result of a pending request. And the agencies, in their response to that complaint, said, no, we will not take disciplinary action on anyone that has a pending request.
And just to add a little bit to that as well, because I know there was some concerns, and I was reading some of the questions coming in here as far as, how if it's a medical request, how they handle these, your essentially your private medical information. Andrea touched on this a little bit before, but essentially the Privacy Act does permit disclosure within the agency for those who have a need for the records. It sometimes, not always, but sometimes includes the supervisory level. But that's it. That's all that the Privacy Act allows. So the agency should not go outside of essentially a need to know. And those individuals who need to know those records in order to make an actual decision or processing or engaging in the interactive reasonable accommodation process. All right, I think I'll take over from here. So Andrea touched on this a little bit as far as potential disciplinary actions for those who are not in compliance with the executive orders, specifically 14043. So the employees who are covered by this executive order who essentially fail to comply, meaning they don't want to do it, they get a reasonable accommodation denied, something along those lines. And after the reasonable accommodation is denied, they still decide that they don't want to get the vaccine. As of now, they are in violation of a lawful order, which does subject employees to disciplinary action. Agencies are directed to initiate before they take, specific disciplinary action. They are directed to initiate an enforcement process to work with employees to encourage compliance. The typical things that they're doing right now are including a period of education and counseling, which typically is a period of 5 days. Essentially, what this is trying to do is just trying to educate employees on the positive impact of the vaccine. Even after this education and counseling, and if an employee does not demonstrate progress to become vaccinated, then, as I mentioned before, the disciplinary actions can follow. This could include a 14 days or less suspension, or if there's continued noncompliance, it could be followed by a proposed removal for employment. Some agencies may jump directly to the proposed removal depending on the circumstances. And essentially what an agency would be arguing in this case is that it promotes the efficiency of the service in order to, because an employee doesn't want to get vaccinated, there's some safety concerns with other employees there. It creates an issue, and in order to promote that the efficiency of the service, the agency is taking that adverse action in order to remove that employee. However, if an agency does start the disciplinary action, and that could be, again, either a suspension or a proposed removal, if an employee or if an agency does start that disciplinary action, if an employee does begin to demonstrate progress to become fully vaccinated, which includes it potentially could even include intent, notifying them, hey, I have an appointment to get, the first shot of the Pfizer, the Moderna, or, have an appointment to get the Johnson & Johnson, or if you've actually even already got the first dose, that would be enough to show the agency that you are demonstrating a progress to be fully vaccinated, and then they should hold off on disciplining the employee and in fact grant them a reasonable time for them to become fully vaccinated. This is also, and Andrea touched on this a little bit, I believe, earlier, but this is also true for employees who have not submitted a reasonable accommodation request. So if there's a disciplinary action that has started and somebody, an employee, has not issued or submitted a reasonable accommodation request, and they do so after a disciplinary action is issued, but before an actual decision is made on that disciplinary action, that employee, if they do submit a reasonable accommodation request, that disciplinary action is held in abeyance until a decision is made on that reasonable accommodation request. As of now, because it's November 18th, the agencies can currently enforce this process because, as Andrea pointed out earlier, November 8th was the last day that you could get any of either the second dose or the first dose of the Johnson & Johnson. So effective November 9th, the agencies can take this process to enforce the vaccine mandate. Unless, again, as Andrea pointed out and we kind of went over, if that employee has received an exception for their reasonable accommodation request, or if they have a pending reasonable accommodation request. As Andrea pointed out, there's no timetable yet for these decisions, especially on the reasonable accommodations. Within the firm, we have seen a few decisions trickle in, but there's, like I said, there's no time frame. We're thinking that it might be around November 22nd or shortly thereafter, where the agencies would, start the counseling process and then eventually taking adverse action if those employees don't want to or continue to not comply with the executive order. Now, as far as the actual process for removal, so there's no exception or there's no special process, if you will, for the disciplinary action if you refuse to get a mandate. The due process rights when you get removed or get proposed removal remain. So meaning that an agency can't change an employee's due process rights, or they can't remove an employee's due process rights just because they refuse to get the vaccine mandate or the vaccine. Agencies are required to follow all normal processes and procedural rights in pursuing any adverse action. And again, this includes any adverse action, which includes a 14-day suspension or less, or again, the proposed removal, which is probably one that would be the most common or the most common questions I saw prior to today's webinar. So the actual due process includes essentially four things. The agency has to provide advance written notice stating the specific facts and laying out specific charges as to why they're proposing this adverse action. The employee has to have a reasonable opportunity to answer, typically a reasonable time to answer, and a reasonable opportunity. Typically, that's between 7 and 30 days. It kind of depends on the agency, but it cannot be less than 7 days. An individual or employee also has a right to be represented by an attorney. That's also a due process right that is provided. And then the written decision must be made at the earliest as possible, but it typically can't be enacted until after 30 days when the employee receives the proposal. There hasn't been any that we've seen, at least as of yet, where agencies have actually started taking adverse actions. I'm anticipating that it's probably going to be something along the lines of failure to follow rules. That would likely be I guess the likely charge, which, it could be potentially a failure to meet a condition of employment. But either way, those would likely be the charges that the agency would file, whether they're doing a 14-day suspension or, again, the continued noncompliance resulting in a proposed removal. But again, you have all of your due process rights. And if an agency does not provide any of these due process rights to you, that's a problem. That's a violation of your due process rights. And that's something that they can't do. And obviously, these proposed removals can come whether you just outright refuse to get the vaccine or if you have a reasonable accommodation denied. In the event that you go through the process, you go through the due process, and you are removed, there are a few appeal options at that point. One of the appeal options is the Merit Systems Protection Board. At that point, if you choose to go that route, you have 30 days from the date of the adverse action being enacted to file an appeal with MSPB, or the Merit System Protection Board. Also, if there's a religious discrimination or even a disability discrimination animus to the agency's adverse action, then you potentially could file an appeal or file a claim with the EEOC, Equal Employment Opportunity Commission. And that must be, you must initiate contact from the date of whenever that event occurs within 45 days with your EEO office at the agency. Sometimes, depending on the circumstances and depending on if you are a union employee, there are possible appeals to the CBA or the grievance process or procedure. But keep in mind that you can't go to EEOC and then if that doesn't work out, go to grievance, or vice versa, go to the grievance first. If that doesn't work out, go to EEOC or MSPB. It's essentially an election of remedies. So you have to choose one and go that route. But those are the possible processes. The EEOC and MSPB are akin, or they're actually, I mean, they're administrative process, but they are an actual hearing. It's an actual litigation process, which includes actual hearings, discovery, witness testimony, responding to some motions that judges may issue or that agencies may file, including in the EEOC or even MSPB motions for summary judgment, which essentially is requesting that the judge issue a decision in favor of the agency without a hearing. There's also depositions and things like that. So I mean, it's a lot of litigation. So in circumstances like that, it's good to have some sort of representation when you're going through any of these appeals processes, especially representation where individuals know what they're doing, know the process, know how to navigate each one of these aspects. So ultimately, the agencies do have the ability to issue some sort of proposed adverse action in the event that an employee does not comply um, with the vaccine mandate. But you want to make sure that the agency is providing you all of your due process rights, because if they don't, that's a big problem, and that's grounds to obviously file an appeal and potentially get that decision overturned. Although they could come back and refile it, and give you proper due process. If they don't give you proper due process initially, that's something that should definitely raise a red flag to you. So that's kind of all I have as far as the disciplinary actions go. But again, I want to bring the point across that if you do not comply and you do not have a reasonable accommodation in place, that agencies are within their rights to at least initiate disciplinary action, which again could include suspension or up to removal. But you want to make sure that you have all your ducks in a row. You want to make sure that all the due process is followed by the agency, especially if some agencies try and indicate, although we haven't seen this yet, but it's a possibility, try to indicate that this is a special circumstance because it's related to the executive order and the COVID-19 vaccine. So, they could just remove you or something like that. That's not accurate. They have to give you those due process rights that you're entitled to.
And related to, what Ryan was saying about this being, basically court at that point, if you wouldn't walk into criminal or civil court without an attorney, you shouldn't be walking into the MSPB or the EEOC without an attorney as well. But, up to that point, these rules and regulations regarding all of these things are very complicated. And if you do, unfortunately face some type of disciplinary action or you are wrongly denied an accommodation request, the earlier you have someone assisting you with this, the better off you're going to be. One of our founding partners, Greg Rinckey, has a phrase of laying bird seeds down so you can follow the trail back later. The earlier you have a representative on your side helping you with this process, the better off you're going to be if you unfortunately do have to get down that hearing line. It's important to keep in mind that what will happen on some occasions is they will try to dismiss claims all the way up to the hearing stage. So you've gotten all the way through the informal phase of an EEO complaint, a formal phase of an EEO complaint, and then agency counsel will make a motion to dismiss based on the fact that the claims weren't articulated correctly all the way back at the informal stage. And if it's not, there's case law to support dismissing someone's claims based on those. So the earlier you have someone helping you, the better off you're going to be.
Yeah, and that doesn't necessarily mean you have to wait for representation at, until you get a denial or something like that. If you get representation in order to assist you with actually, like, if you have a valid exception, a reasonable accommodation, and you need assistance with that, you could potentially avoid the entire situation. And, just to kind of piggyback that a little bit, and I know Andrea touched on this a little bit more, but, as she said, the process for accommodations is not new. So even though an agency may have put a deadline, hey, we need these reasonable accommodation requests in by November 8th or November 15th or November 22nd, that doesn't mean that you can't submit that afterwards. In fact, if you request a reasonable accommodation, the agency is obligated to engage in an interactive process with you. So if they try and deny you a reasonable accommodation for untimeliness, that's a problem.
And, kind of related to, but separate from, but particularly for those that are Fed contractors, it's important to keep in mind the OSHA rules as well. The OSHA rules had a direct impact on the executive order for federal contractors in that it pushed the compliance date back for federal contractors to line up with the OSHA rules. And it's also important to note that the OSHA rules are currently stayed by the Fifth Circuit. They also declined to lift that stay. So as of right now, the administration has said that they are not going to move forward with the OSHA rules until that stay is lifted and the case is decided. Other important cases that you really want to keep an eye on is the one I mentioned earlier, Church v. Biden administration. It's important to keep an eye on that one because a lot of the things that we hear concerns about, why can't I show that I have an immunity due to a previous exposure? Why can't I do X, Y, Z? That case is bringing up a lot of those issues in the federal circuit right now. So that's going to be a bellwether case for situations like this moving forward. I mentioned before that the temporary restraining order that they requested was denied. The issue with federal lawsuit cases right now is that there's no harm yet. And what we mean by that is that, you haven't lost your job yet. You haven't faced, a wrongful denial, hopefully yet. If you have, obviously you need to go to the EEO and begin a claim within the 45 days, like Ryan said. But, the reason why it's important to bring that up as well is if they denied the TRO, one of the other reasons why it could be denied and why this one was denied was because there's no irreparable harm. And what they mean by that is there is an avenue for you to pursue to seek relief beyond this temporary restraining order and this court hearing this complaint right in front of them. And those avenues are, what Ryan touched on, the EEO process and the MSPB process.
So I think that's it as far as what we have to say. I know there was some questions that were submitted. Pat, how much time do we got left? Are we still okay?
Yep, plenty of time.
Okay, so I know there was a couple, or not a couple. There's plenty of questions that were submitted prior to this, and I want to touch on maybe a few of them. A lot of the questions that Andrew and I got were, quit versus being fired in the event that you're facing a disciplinary action, or quit being, whether it be resignation or potentially retirement. So ultimately, you may not like this answer, but that's ultimately up to you. If you are eligible for retirement and you don't want to be subjected to the vaccine, that may be an avenue that you want to go to. There's still a lot of litigation going on at this point. But in the event that you weren't able to get a reasonable accommodation, or you're just outright refusing the vaccine, if you are retirement eligible, that may be something to look at, because in the event, like I said before, that you refuse to get the vaccine, the agency is very, very will likely take adverse action against you. And obviously, if they do remove you, then, you obviously have the avenues that I was speaking about earlier, and Andrew touched on, as far as MSPB and EEOC. But in the event that you lose that, then there's going to be a termination on your record. And, if that's something that you want to avoid, it may be something to look at. As far as kind of piggybacking that, as far as a potential argument for essentially a forced retirement, or what they call a constructive discharge or a constructive retirement. An event like that, unless there's some sort of due process issues going on, it really wouldn't necessarily be a good argument. It would be akin to, like I said, maybe like I said previously, maybe a condition of employment, right? So a lot of you on here possibly have a security clearance, and many of you, in your position descriptions, or even later on, you transfer to a different position. Those positions require you to have a security clearance. It may be along the same lines that the agencies would argue that, this is a mandate, an executive mandate, that's a lawful order that came down. You failed to follow these instructions, or you don't meet this condition of employment, and therefore meaning the agency is well within their right to to take action against you. So that would likely be an argument for them that they have a valid reason for taking this adverse action, which is something that they look at in constructive discharge claims in MSPB, and also something that they look at if you argue, some sort of discrimination in the EEOC. Agencies do look at, what they call reasonable or legitimate non-discriminatory reasons for taking these types of actions. So there's still a lot to look at there, but those are some of the questions that I've been seeing here. Not sure if Andrea saw any additional questions she wants to touch on.
Yeah, basically related to what I was discussing earlier, and what Ryan just touched on, you really want to make sure that, if you are wrongly denied an accommodation request, if you are, not given those due process rights, a lot of the questions that I hear on consults when I do these is, well, how do I file a lawsuit? What do I do? Well, you need to make sure you exhaust your administrative remedies first. That means going through the EEO or the MSPB. That's where you're first going to be able to get that relief that you're looking for. The other questions that we see pop up a lot are, related to, can they deny my accommodation request because my condition is not one that's listed on the CDC recommended? No, the medical accommodation process is very specific in that it is an individualized process. There is no right or wrong answer if your doctor, who knows your medical history, is stating that you should not take the vaccine. That is what your doctor is telling you, and that is what you should submit to the agency. Under no circumstances, whether it's a medical or a religious, should you feel deterred from applying for one if it qualifies, or if you qualify for one. This is well within your rights to ask for these accommodations, as long as you qualify for them. So the CDC recommended guidelines are just that. They're recommended guidelines. If your doctor says it, submit it anyway.
Yeah, and to kind of piggyback on that a little bit as well, there are a few questions in here as far as, pregnancy and, if that's a valid medical reason. There's guidance from CDC that's saying that it's safe if you're pregnant in order to get the vaccine. However, if your doctor has some sort of reasoning as far as, maybe it's a high-risk pregnancy, or maybe there's some other issues or reasons why your doctor feels that, you can't get the vaccine while you're pregnant, that would be something that, the agency should look at and not outright just deny. So even though the CDC provides, some guidance saying it's safe to do that, if your doctor has some other reasons, it's not a one size fits all. So, there are different, circumstances. Every reasonable accommodation case is looked at, or should be looked at individually and on a case-by-case basis, because everybody's facts and circumstances are different.
One of the other things that we see a lot is, what should I be putting in my religious accommodation request? I always turn that around and say, what should you not put in a religious accommodation request? I understand that there are a lot of very strong personal beliefs about this situation, but it's important to remember that there is case law and there is guidance regarding what can be approved and what can be denied. So you want to keep your request tailored specifically to your religious belief. And you don't want to put in there political arguments, scientific arguments, medical arguments, things along those lines. Everyone is entitled to their own beliefs, but if we're looking at this from the lens of approval and getting your accommodation, if you qualify for it, you have to maintain the religious aspect or sincerely held belief aspect and avoid putting in those other reasons. That being the case is because agencies are allowed to legally deny an accommodation request if the employee presents a legitimate reason for the agency to believe that the employee is seeking the accommodation for a non-religious or non-spiritual or non-sincerely held belief reason. So at that point, it doesn't even matter what the employee believes as far as their religious or sincerely held spiritual belief is, because what it's going to boil down to is the agency thinks they are seeking the accommodation for a reason other than that sincerely held belief. Another question that we see commonly is, is this unconstitutional? As it stands right now, no. As we are sitting here talking to you today, no. But this kind of piggybacks off of what I was saying earlier. This is a very fluid, this is a very new situation. This is changing by the day. So like I said earlier, please make sure that you're keeping an eye out on any of the cases that we mentioned here today. Keep an eye out on, news stories related to the mandate. And, if you are in the process of applying for an accommodation, it's very important to watch those because it's going to play a role if something does change in your accommodation.
I saw no one as far as if an employee gets fired for not getting the vaccine or not getting their RA approved, will they lose their federal pension when they're entitled to it? The answer to that is no. This is not very likely not going to be a misconduct related to financial issues or something like that. The only way that a pension or retirement would be affected is if there's some sort of financial misconduct, embezzlement, something like that, that would have an impact on that. So, every case is a little bit different, but the short answer to that is no.
Related to the EEO process, applying for an accommodation is a protected activity under the EEO. If for some reason, hypothetically, an employee started facing some type of retaliation because they applied for an accommodation, or if they started receiving retaliation by their supervisor for being approved for one, these are just very general examples, but if the employee faced some type of retaliation surrounding their accommodation request, you are allowed to go to the EEO regarding that retaliation and file a claim based on that retaliation.
Andrea, one of the questions I got was if a federal employee is 100% telework, why are they required or forced to be tested for COVID, or why do they, why does the vaccine mandate apply to them? You answer that question?
Yeah, absolutely. So whether someone has a telework agreement or if they are remote, because there's a difference between the two, the agency still has the power to require the employee to come into a facility. The reason being is if there's a required security update to their equipment, for example, that can't be pushed through via the internet, that would be a situation in which the employee physically needs to go to a building. So because the employee would physically need to go to a federal facility, that is why it applies to them. But related to that, even though those situations are few and far between, that's why if you apply for an accommodation, you could ask that, your accommodation be on the rare instances that you go in, you would mask, physical distance, and show a negative test, just as the visitor policies would be related to federal facilities.
Another question I got was, is an accommodation in place as soon as they submit it? The answer to that is no, because it hasn't been approved. Now, as we said before, once you submit your accommodation, they can't take any adverse action against you until a decision is made. But your accommodation is not valid until there's an actual decision or approval on that. Andrew, you want to maybe take one more question and then we can kind of wrap this up?
Yeah, absolutely. I know that there's a lot of concern based on some of the questions that we received regarding agencies not giving complete information about how to apply for an accommodation. If that's the case, make it known to the agency through some manner, whether it be your EEO office, your first line, second line, whoever, that you are seeking an accommodation. As I said earlier, you know, the processes have been in place for these accommodation requests for years. So making it known to the agency that you are requesting an accommodation is good enough to at least preserve your right that you are requesting an accommodation. So at minimum, even if they're not giving you all of the information that you need to fully comply with whatever policy your agency has decided to use, make it known that you want an accommodation and follow through on that initial request and submit the documentation when you receive it.
All right. Well, I want to thank everybody for coming today and appearing. I hope this was informative. And Pat, I think you can wrap it up.